Honorable Minister, Sri Arjun Mengwal, Justice Deepak Mishra, my friend Fali Nariman, Mr. Sham Diwan, with whose father I had very intense relationship, and he was one of the persons who molded me, and Arnab Goswami, my good friend, and Mahesh, who thought of inviting me because he felt that there should be a voice outside the jurisprudential group, which is both the judges and the lawyers put together. You know, it is my fortune, my pride, an opportunity for me to share my thoughts, not as a lawyer, but as someone who had come in contact with law, fell in love with law, became passionate about law, because of a series of accidents, coherent accidents, which took place in my life, starting from emergency and the days before. You know, we were all underground at that time. We couldn't go to our houses. And I had just then qualified as a chartered accountant and got married also. So it was at that time I came to know the essence of the Constitution, the fundamental right, the need for it. Otherwise, it was just a piece of paper. Nobody knew what fundamental right meant before probably the emergency was imposed. Very few people knew about its impact, maybe most in the field of commerce or property. There was no idea of what it means to the normal, ordinary human being. I was given the responsibility of maintaining 150 families to provide rations for them who were in jail. They had done nothing wrong. So I knew what it means to have fundamental rights, to be outside, how to approach the judiciary. This is what made me to study the Constitution in depth. In fact, emergency became the first major impact on me to study the Constitution. And before I go into what transformed me from being a chartered accountant into someone who had developed such passion for law, I will talk about Ram Jethmalani. You know, Ram and Fali and people like them are the ones who groomed me, encouraged me. And they found that, you know, I was not a lawyer, but they never discriminated my ideas on law. I could put provocative questions to them, contrary questions to them, even questioning their very idea about what they were proposing to argue in courts. They would tolerate it, they would encourage it. In fact, I was just sharing with Fali Nariman how in the Indian Express demolition case we worked. He said how much work we put. He also said how little work is being put today by the bar. It's a comparison. How the government of India functions, from the allocation of business rules to the authentication of document rules. Because the government of India said the secretary signing on behalf of the government of India doesn't have the authority to give sanction for the building plan. The government disowned the whole thing. So we had to construct the whole Article 73 downwards to how a secretary signs, meaning the President of India signing. It was a 72-page affidavit which he had to file in the Supreme Court because the government disowned its own signature. You know, this is how law develops. Law develops by hard work, by the passion to fight for rights. So, when I started with Ram, you know, he was one of the most comfortable human beings. First of all, leave law aside. Such a comfortable human being. I said, Ram, you are wrong. He will listen to it. We will all be shouting and talking. He will be reading as if nothing is happening outside. And he will read the judgments which were quoted against him. And we would have 20 judgments in favor of what we have to speak. Ram will find fault in the judgment that have been quoted. And he will say that to find holes in the judgments of the opponents is what will win the case for you. Not that you quote alternative judgments to present your viewpoints. These are all brilliant legal strategies to which I was initiated when I was just 27, 28. An opportunity which I got purely out of accident of being the advisor to Ramnath Goenka, who had to face the toughest time in terms of government attack on him during the emergency and afterwards, even after the emergency, the building demolition case, the customs duty case, and all the cases that were launched. 300 cases were launched in a period of 30 days. All these things we had to fight, and perforce we had to become lawyers. In Indian Express, almost 6-7 people who had nothing to do with law turned to be good lawyers, thanks to the kind of assault that the government made. And we had to defend that institution and the civil rights which the institution represented. That's how I came in contact with Fali. That's how I came in contact with Nariman, Anil Diwan, to stay. It all started with Nani Palkiwala. Then Sirwai. I will tell you some of these things, this anecdotal effect of the association I had with all these people. Unbelievable. No university, no law textbook, no library can give the kind of knowledge which I could get by my association with these people. So about Ram. You see, Ram, somebody asked how many times he was Rajya Sabha member. I think our minister asked. He was a Rajya Sabha member 4 times. Of course, he was in Lok Sabha. He was in Rajya Sabha member 4 times. He was Shiv Sena Rajya Sabha member. He was Janata Dal Rajya Sabha member. He was BJP Rajya Sabha member. And he was RJD Rajya Sabha member. He completely unified India. The man had immense, he had a huge heart. In fact, he told me, Guru, will you help me to defend Lalu Yadav? I said, Ram. You see, Ram and me had a very open exchange on many issues. You see, I was also called a fighter against, a crusader against corruption. I would always screen a client 20 times. I will take certificate from my friends that I can take him as a client, because tomorrow somebody should not say that I have taken a wrong client or benefited by a wrong association. But Ram will take the most acknowledged rascal and defend his case. And still he was called a crusader against corruption. I said, Ram, how lucky you are. We are giving up 90% of our opportunities to get the name that we are fighting against corruption. But you are able to fight against corruption, call a crusader against corruption, and at the same time represent these people and make money out of them. In fact, a very interesting dialogue took place between Ramnath Goenka and Ram Jethmalani. In fact, Fali Nariman will be very happy to listen to that. Ramnathji's one of the greatest pride is that none of the senior councils would charge him. Guru, Nani doesn't charge me. Fali doesn't charge me. Ram doesn't charge me. Soli doesn't charge me. Ramnathji used to feel so proud that these great guys are not charging him. In fact, he showed me the bill which Fali Nariman had sent after completing the arguments on the demolition case. And almost 35-40 days the case went on. I think it was after the Keshavananda case, it was the longest case argued before the Supreme Court till then. So when that bill showed that Fali had charged him only for the clerkage. He must have shown that bill to Fali. He must have shown this to 100 people, not to praise you, but to make others feel how important Goenka was. So you must understand, Arun Shourie used to say, Goenka is Article 19(1)(a). He represented the freedom of India. It is not the press freedom of today. You know, those who had worked in the Indian Express those days, the kind of troubles they had undergone, salary deferment, salary cut, these are all the things which journalists underwent to defend press freedom. So Article 19(1)(a) was represented by Ramnath Goenka at that time. And so Ramnath Goenka asked Ram, you are defending so many people pro bono. How are you making your money? And Ram said, that's a very simple formula, Ramnathji. I make money depending upon the trouble my client is in and the weight of his purse. This is how he said, I make money so that I can do pro bono work. These are all things. With how many tall people we moved. Where are those tall people today? In fact, this is how I am going to end my speech. That what we need today is not tall legal brains, not tall judges, not tall media men, but tall people. Tall men, sun crown. This is what we need. Now, going into what is my personal qualification to be here. I am a chartered accountant, but chartered accountants think I am not a chartered accountant, I am a journalist. Journalists think I am not a journalist, I am a chartered accountant. But I am happy, ultimately, somewhere I have been asked to share my thoughts on a subject on which I have developed some empirical skills. And I am happy this audience of people of jurisprudence are listening to me, which even my own profession and the adopted profession as a journalist has not afforded me the chance. So my first qualification is that I am a friend of Ram. That is why I first felt that I should be present here. And my next qualification is that I have to labor to prove to you that my introduction into the field of law is because of my passion for understanding the Constitution, constitutional rights, people, and the role of the government and the role of the judiciary. This is what made me not only feel comfortable with law, compassionate with law, and develop passion for law. So, if you look at the schooling I had done, with Nani to Sirwai to Fali to Ram, this kind of familiarity with people of the highest attainment in the field of law and jurisprudence, not many people would have got, but for the fact that I was associated with the Indian Express, and through Indian Express I was fighting for this great cause, which proved to be the best years of my life. Achyut Patwardhan once told me, I don't know how many of you heard the name, he was the man who led the 1942 Quit India movement. He told me once, whatever you achieve in life, Guru, the years that you spent with the Indian Express will be the best year in your life. That is how it proved to be, because that expanded not only my vision, my knowledge, my understanding, and I was an Ekalavya of all these people, and that is how I am standing before you. Now, I'll tell you how I was encouraged. In a very important criminal case from Calcutta, I wrote a 90-page complaint charging with fraud, forgery and all that. Ram told me, Guru, in my life, I have never come across a 90-page complaint. I said, Ram, I am applying the principles of conspiracy under the Calcutta rules for civil suit for this criminal case, because either we win the criminal case at the opening or lose it forever. He said, okay, I go by your assessment. And that case was approved by the High Court. The magistrate issued, you know it, what the case is. I don't want to mention the name of the case. So the process was issued, and the High Court, there was a bitter battle between Ram Jethmalani and Shanti Bhushan. Shanti Bhushan said that the complaint is 90 pages it means that there is nothing in the complaint. That is why the weight of the complaint is now going to decide the fate of the case, or the quality of the content in it. So finally we won before the High Court. Ram was in London. I rang up Ram and told him, how nice he was. Guru, my judgment was wrong. This 90-page complaint won the case for us. Can you find any other great mind encouraging a small man like me and enhancing my level of confidence? This is how I became familiar with law and comfortable with law. And now coming to the issue that has been debated so far, the idea of basic features or basic structure of the Constitution. I will again take you to an anecdotal reference with Mr. Sirwai, H.M. Sirwai. In 1980s in the Indian Express had carried on a campaign against Antule. And Antule and Dattasamman joined together and they shut down the express. And if Antule, and he was the chief minister, and Dattasamman, who was a person of physical means of handling, the people were not willing to come to the office. The journalists were afraid. Even the guards were afraid of coming to the office. So in that situation, we decided to file a writ petition. And then we decided to close down the paper. And the government refused to give permission under Section 28O of the Industrial Disputes Act. So we filed a writ petition where we said that there are reasonable restrictions for the right to freedom of expression, but for the right to silence, there is no restriction. Right to silence is absolute under the Constitution. This is what Sirvai was to argue. So when I went to brief him, he said, I know everything. You have said this in page 21, this in 29, this in 48, this in 62. The briefing was over in 2 minutes. So I told him, sir, I want to sit with you for some time. And you have closed the whole thing in 5 minutes. What do you want to ask? You can ask. Sir, can you tell me something about Golaknath case and Keshavananda case? I had Golaknath knocked out. I said, yes. Sir, I am a student of law. I have read your constitution books. And I am fairly familiar with how the constitutional amendments moved in 1971 onwards. Can I ask you a question? Sir, previously, the unamendability of the Constitution was limited to Part 3 of the Constitution. And that is what you fought against. That you cannot say fundamental rights cannot be amended. That was the case of the government. But you have ended up with a judgment which has extended the unamendability to the whole of the Constitution. He said, yes. This is an extreme reaction. Golaknath was a reaction. This is an extreme reaction to Golaknath. This is what we have to understand when we are talking about Keshavananda case. The political system and the judicial system, when they lose mutual trust, what happens? The political masters, the political sovereign always wants to control everything. The simple point I will mention to you, when Surya Prakash is here, he only brought it out. When the first amendment was proposed to Article 19(1)(a), the idea was Jawaharlal Nehru wanted the restrictions without the word reasonable. But all the people sat together and said, no, it's not correct. Even though you are Jawaharlal, we advise you that the restriction should be reasonable. So there was an internal mechanism in the political sovereign's mind which made the word reasonable restriction possible in the legislation. This was lost when Mrs. Gandhi came. You know what happened? Bank nationalization, and then Privy Purse case, and then the conflict between the judiciary and the executive started. And Keshavananda was one of the, Golaknath case was one of the principal drive of this. And it is true that it was a too tightly worded judgment for anyone to be comfortable with it, though it was a very well-written judgment. Not that all judgments well-written are good judgments. And so that went into the reaction. Now we do not know which part of the Constitution, and that Honorable Chief Justice Mr. Deepak Mishra listed the things which the constitutional makers did not see as the unamendable part of the Constitution. For example, it is now mentioned about the federal structure. Can India not think of tomorrow a presidential form of government? Let's assume the Constitution votes for the presidential form of government. Can the Supreme Court strike it down saying that it violates the rule of the basic structure of federal structure? You know, I think there is lack of balance. And my view is a dissenting view. Any dissenting view is an appeal to the future and brooding conscience of judiciary. This may appeal. So let us not think that the basic structure theory is so well-founded. From a concrete position of unamendability of Part 3 of the Constitution, we have gone to an abstract position of unamendability of any part of the Constitution. And if the Supreme Court decides that this is the basic structure, who is to question it? For example, the NJAC case. It could well have been read down that you cannot override the two members of the judicial system, and we read it down. It's not possible. The matter would have been solved. But the question of reading it down would not have given the judiciary the position that it wants, namely that it wants independence from the government. That is also not correct. In fact, I had a discussion with the Reserve Bank Governor, Y.V. Reddy. He told me that we should be independent, but there is also some interdependence. That is how the system works. And I think that we are now 50 years after this judgment was pronounced, and there has been, as the Honorable Chief Justice said, that there has been enough empirical evidence to understand this. And I think my appeal is that the framers of the original Constitution had kept one thing in mind, that the fundamental rights of the people should not be affected, whatever is the system of governance. Now, the basic structure theory brings about a situation where the judiciary will decide the system of governance also, which is not the intention of the original framers of the Constitution. It may work for some time, but a very powerful sovereign coming, and powerful sovereign can be produced by democracy. It's not that powerful sovereign will be produced by any method other than democracy in India. Such a person may take a position. Again, a confrontation can come between the judiciary and the legislature. I think it would be within my rights as a citizen to appeal to the judicial fraternity and also the entire intellectual basis of judicial functioning, law, courts, that we should have a relook at the basic structure theory. And with that, I finally want to say only one thing. I have been seeing what's happening in the last 40 years. The state of the court, the state of the bar, the state of the media, the state of the discourse. Now Ram is not there. We see a dwarfing. All tall people, when they disappear, we don't see an equivalent person on the horizon. We need tall people, sun-crowned, and they cannot come. If they are going to discuss only about their fee structure for cases and the turnover that they achieve in a month or in a year, we have to move away from all. At least some people have to move away from all this. Tall people cannot be produced by mere money making. In fact, tall people are those who keep away from this. So we need to pray for, as the American senator did when the Watergate case was going on. He said we need tall people, sun-crowned, who live above the fog of, I forget the full poem, it's a beautiful poem. And with a drop in his eyes, he closed, saying that no system will work unless there are tall people. We have to produce tall people. Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.